of the states and territories of Australia that are self-governing are separate jurisdictions, and have their own system of courts and parliaments. The systems of laws in each state are influential on each other, but not binding. Laws passed by the Parliament of the Commonwealth apply to the whole of Australia. The organised system of law and government now in force in Australia is historically dependent for its legal validity on a series of British statutes, notably including the Commonwealth of Australia Constitution Act 1900. The authority of the United Kingdom Parliament to enact those statutes depended on the acquisition of the Australian continent as a territorial possession of the British Crown. Although the laws of the Australian colonies differed from the UK in many respects from the beginnings of settlement, the underlying patterns are thought to reflect the common law tradition as received from Britain. Reception of English law. The legal institutions and traditions of Australian law are monocultural in character, reflecting its English origins. Influenced by contemporary ideas of international law, sophism, and private ownership, the British regarded the Aboriginal peoples as being too primitive to have lawful possession of the Australian continent. They chose to treat New Holland as terra nullius, meaning an empty place. Since the Privy Council had held that uninhabited lands settled by English subjects would be governed by the laws of England, there was no place for Aboriginal native title to land, nor for the recognition of Aboriginal custom or law. The reception of English law was clarified by the Australian Courts Act 1828, which provided that all laws and statutes in force in England at the date of the enactment of the legislation should be applied in the courts of New South Wales and Van Diemen's Land so far as they were applicable. Since Queensland and Victoria were originally part of New South Wales, the same date applies in those states for the reception of English law. South Australia adopted a different date for reception, as did Western Australia. The earliest civil and criminal courts established from the beginnings of the colony of New South Wales were rudimentary, adaptive and military in character. Although legality was not always observed, the courts limited the powers of the governor, and the law of the colony was at times more egalitarian than in Britain. By 1824, a court system based in essence on the English model had been established through Acts of the British Parliament. The New South Wales Act 1823 provided for the establishment of a Supreme Court with the power to deal with all criminal and civil matters, as fully and amply as Her Majesty's Court of King's Bench. Common Pleas and Exchequer at Westminster. Inferior courts were also established, including courts of general or court of sessions, and courts of requests. Representative government emerged in the 1840s and 1850s, and a considerable measure of autonomy was given to local legislatures in the second half of the 19th century. Colonial parliaments introduced certain reforms such as secret ballots and female suffrage, which were not to occur in Britain until many years later. Nevertheless, acts of the United Kingdom Parliament extending to the colonies could override contrary colonial legislation and would apply by paramount force. New doctrines of English common law continued to be treated as representing the common law of Australia. For example, the doctrine of the famous case of Donahue v. Stevenson, from which the modern negligence law derived, was treated as being latent already within the common law at the time of reception. Divergence. While the Constitution of the Commonwealth of Australia was itself an act of the British Parliament, Britain's role in the government of Australia became increasingly nominal in the 20th century. However, there was little momentum for Australia to obtain legislative independence. The Australian states did not participate in the conferences leading up to the Statute of Westminster 1931, which provided that no British act should be deemed to extend to the Dominions without the consent of the Dominion. The Commonwealth did not invoke the provisions of the statute until 1942. Complete legislative independence was finally established by the Australia Act 1986, passed by the United Kingdom Parliament as well as those of the Commonwealth and states. It removed the possibility of legislation being enacted at the consent and request of a dominion, and applied to the states as well as the Commonwealth. It also provided for the complete abolition of appeals to the Privy Council from any Australian court. The Australia Act represented an important symbolic break with Britain, emphasised by Queen Elizabeth II's visit to Australia to sign their legislation personally. Legislative independence has been paralleled by a growing divergence between Australian and English common law in the last quarter of the 20th century. In addition, a large body of English law received in Australia has been progressively repealed in state parliaments, such as in New South Wales's Imperial Acts Application Act 1969. Australian republicanism emerged as a movement in the 1990s, hoping to eventually change Australia's status as a constitutional monarchy to a republican form of government. Judicial system. Australia's first system of courts, modelled on the historical English court system, was eventually replaced by courts with other names and structures. The court structure in Australia today is a complex mosaic. Courts may be characterised by whether they are state courts or federal courts, whether they are general or specialist courts, and whether they have a general or limited jurisdiction. Federal courts. The High Court was established with Australian Federation, to act as a court of appeal for the country as a whole. The High Court also hears cases about the Australian Constitution. It also has the power to declare laws unconstitutional, which means that the laws, regardless of whether they pass Parliament, are not valid. There are also federal courts with a jurisdiction defined by legislation. Major developments in the federal court system occurred in the 1970s. In 1976, the Family Court of Australia came into existence, exercising jurisdiction mainly under the Family Law Act 1975. In addition, in 1977 the Federal Court of Australia came into being, and now exercises jurisdiction in matters of commercial, administrative and industrial law arising under federal legislation. In 2000, a federal magistrates' court was established. State courts, in certain matters, may exercise jurisdiction under federal law. In response to delays, there has been a growing practice of case management by the courts. State and territory courts. All states and territories have a Supreme Court. Jurisdiction can be excluded by operation of a state statute. This has happened, for example, with environmental and planning matters, which are dealt with by the Land and Environment Court. These types of courts can remit cases to lower courts or remove cases initiated in lower courts. Supreme courts are superior courts, which means that their decisions are binding on lower courts. By contrast, the decisions of inferior courts are subject not only to appeal in the normal manner, but to review as to whether the matter was within the jurisdiction of that court. All jurisdictions, apart from Tasmania, the Australian Capital Territory and the Northern Territory, have an intermediate trial court, called a county court in Victoria and district court in the other states. Most jury trials take place in the intermediate trial courts. At the bottom of the court hierarchy are the courts of summary jurisdiction, called magistrates' courts or local courts. In the Northern Territory there are two types of court of summary jurisdiction, one exercising criminal jurisdiction and one exercising civil jurisdiction. In their civil jurisdiction, inferior courts operate within jurisdictional and monetary limits. The monetary limits of the inferior courts have increased substantially in recent years as a result of pressure of judicial work downwards to the courts lower in the hierarchy. All Australian states have criminal injuries compensation schemes. New South Wales, Victoria, and Western Australia have created separate victim compensation tribunals. In New South Wales the body is called the New South Wales Victim Compensation Tribunal, in which applications can be made even where a person has not been charged with a criminal offence. In Victoria and Western Australia, the body is called the Victims of Crime Assistance Tribunal. In the Australian Capital Territory and the Northern Territory, awards are made by the Magistrates Court. In South Australia, an award can be made by the District Court. In Queensland, an award can be made by the court that heard the criminal proceedings. In Tasmania, an award can be made by the Master, Registrar or Deputy Registrar of the Tasmanian Supreme Court.